Dear ladies and gentlemen, we are about to begin with the second part of the panel, Human Rights, Adjudication and Natural Law. Within this panel, we have Tana de Campos as the moderator, and she is assistant professor at the Catholic University of Chile. Within this panel, we also have Pier Paolo Pigozzi, who is going to talk about the moral absolutes and international adjudication on jus cogens norms. But we will also have Paul Yowell, who is an associate professor at the Faculty of Law at the University of Oxford and also a fellow at Oriel College. He will speak about the subsidiarity and the ECTHR's climate change judgment. Thank you very much. Let us listen to them.
Thank you. Thank you for the invitation to the organizers. I'm going to, I cannot avoid saying this at the beginning of the talk. So I think it's 12 years ago when Professor Finis was supervising some of my research, I constantly faced the comment of not having a thesis. So now I'm going to start by disclosing my thesis. So the notion of jus cogens is a false image of natural law, I contend. Jus cogens does not introduce basic principles for human flourishing into international law, nor bring international law closer to the methodological requirements of practical reasonableness. I would say instead it becomes more and more the case that natural law lawyers, out of respect of truth and willingness not to mislead, ought to abandon the idea of jus cogens norms. We know that jus cogens norms, especially for, we know that now they were subject of a set of conclusions by the International Law Commission. And the study of the International Law Commission exactly was triggered because so much controversy and so much unknown regarding what are these norms, how to identify them, and what their effects are. So I'm not advocating for abandoning something that is well established as a legal source of obligation, but something that is instead is full of voids. We ought to acknowledge that we live in a time when judges, and more so the holders of the international mandates, have become, and I quote Professor Finis, willing to change the law and apply it as change to the judicial determination of a specific item of litigation in a specific contested case. They are misleadingly and therefore morally indefensibly asserting, at least by implicature, that they are applying the law that was adopted in the past. And they are doing so exactly due to the most tempting temptations, as Professor Finis put it yesterday, of the public interest, the common good, as if it were a state of affairs which could be accomplished at the end of some period of instrumental effort. Instead, I think, instead of jus cogens, what natural law has to offer to international law in both the content and method is through moral absolutes. So I would say that I would start with the issues in international law. In this part of the paper, I discussed that the whole idea of having jus cogens norms is part of the general criticism to the international legal system as one that is positivist and voluntaristic. Some say state-centric because all the obligations come from the will of states through treaties or customary norms. In fact, there's this dicta of the Lotus case in 1927 by the Permanent Court of International Justice, saying that asserting that the very nature and existing conditions of international law is one that governs relations, and I'm quoting, between independent states. The rules of law binding upon states therefore emanate from their own free will as expressed in conventions or by usages generally accepted. Restriction upon the independence of states cannot be therefore presumed. So in this way, the Lotus case laid down the idea of international law as a permissive set of rules, one that has the state will at the center of the source of legal binding commitments, and one that presumes that states are free to act. Lotus, throughout these almost 100 years, has been very contested. We cannot hide the fact that it has been contested. Some criticize this as not having a real grounding in what international law is. Others, and more texts of international law, canonical texts, I would say, cite this in disagreement, but cite it as what it is. And more so, I say that generally in teaching, when we overview the practice of international law, it shows that this stance of the International Court in Lotus is true. When we visit and revisit the work of the International Law Commission, we find that in their reports, it's always the will of states, the reference point for any new forms of interpretation of previous acquired treaties or customs. And that, for example, international organizations do not have a role, not even in creating new obligations, but in actually interpreting authoritatively previous obligations acquired by states through treaties. Recently, we have, in one of the most recent works of the International Law Commission, we have the interpretation of treaties on what it means, the ulterior practices of states and the posterior agreements after the treaties. How does one interpret treaties through this phrase of the Vienna Convention of Law, the treaties? What does it mean, ulterior practices? And what the International Law Commission, after extensive research, what it says is, well, we know that it does not mean what international organizations say, for example. They can trigger the acts of states for them to start reacting towards what an international organization, international court said, and reaffirm that practice, but it's the state's practice that matters. This is very recent work of International Law Commission, and to me, this line of work that, because of the time, I cannot go one by one on the reports and case law, but this precise line of work ratifies that international law continues to be one that is voluntaristic and positivist in the sense of the Lotus case. So for international lawyers, use Cogens is an attempt to fix this and trying to make sense of an international law, international public law, that has provisions on environment, on human rights, on humanitarian law, on international criminal law, and try to make sense of these provisions as if it was a set of rules of public order, in the French sense of public order. Use Cogens attempts to fix this ultra-state-centric view of international law, with which I don't necessarily agree, but the facts are that those are the characteristics, the features of international law nowadays. So when the notion of use Cogens enters the stage, and precisely, I think Sir Fitzgerald was one of the rapporteurs that had a very important role in the discussion of this Article 53 of the Vienna Convention of the Law of the Treaties. And the definition we have about use Cogens is that it is a norm accepted and recognized by the international community of states, by the international community of states as a whole, as a norm from which no derogation is permitted and which can be modified only by a subsequent norm of general international law having the same character. Yet we know that natural law principles hold good, quote, however extensively they have been overlooked, misapplied, or defied, and however little they were recognized. So that they are recognized by the community of states as a whole is no indication that their substance is one of, say, a set of natural law principles. Moreover, jus cogens is about discernment of precepts in the form of X is befitting or unfitting human nature. X being torture, aggression, piracy, or execution on lawful death. But there's no discernment of any reasons, even less so of pre-moral well-being as desirable, if anything. If anything, I would say international law works completely contrary to this assumption that there is some attainable form of well-being for humans. Even in the best account of how to determine what are jus cogens norms, I think Mary Ellen O'Connell argues for a collective judicial discernment, a discernment of, again, precepts in the form of X is befitting or unfitting human nature. But in this way, it is the discernment of a will of a superior. And I think here, if before we incur it in the rationalist thesis, here we go into the voluntarist thesis. There's no argument for rational necessity of which means or for what ends in discerning jus cogens, as the discussion is phrased now. I think this also proves the point that jus cogens does not bring international law closer to the methodological requirements of practical reasonableness. Jus cogens seeks to further, I would say, some sort of an involuntarism of international law, some sort of authoritarianism in an age in which judges act in the way we have heard yesterday by Professor Finis. I say they act in this way generally, and as we know of evidence even from the previous panel, how we criticize the European Court of Human Rights and the Inter-American Court of Human Rights. The idea that jus cogens has some sort of hierarchy puts into the scene that, again, this idea of winner takes all and the loser gets nothing. But human rights have no hierarchy, supposedly, yet. For example, Advisory Opinion 18 of 2003 and 24 of 2017 from the Inter-American Court of Human Rights tell us they discover a new norm of jus cogens. The principle of equality and non-discrimination is jus cogens according to the Inter-American Court. And then a decade or more so later, it tells us that in gender, the idea of equality and non-discrimination, in gender issues, equality and non-discrimination as a jus cogens norm mandates that the marriage between people of the same sex is a human right protected by the American Convention. Moreover, in the Beatriz case versus El Salvador, now litigated, just we're waiting to hear the judgment by the Inter-American Court, the argument was advanced that equality as a non-discrimination mandates that the rights of women and their equality trump the protection of life from the moment of conception. And there are many more overreaching consequences of the jus cogens doctrine and as to what it means for the well-settled principles of state immunity, for state equality among other states. And yet we find natural law lawyers such as Stephen Hall and Mary Ellen O'Connell trying to make the case for jus cogens norms. I said instead, if we look at if we're trying to solve this problem, this practical problem, through real natural law and not a false image of it, we pay attention of how moral absolutes work. And you see that moral absolutes, as for the content, as to bringing us closer to the set of principles of natural law, they rest on a full account of human well-being from the very fact of the pre-moral goods. This is an account that does not shy away from the full complexity of human life, where basic human goods give open-ended reasons for action, freedom, and different plans of life. There is a big quota of realism in dealing with moral absolutes. In this sense, they are absolute or exceptionalist norms. And this is something said by Professor Finis in his work on moral absolutes. He reminds us that no one in the Christian tradition should suppose that the rightness of an action consists in its efficacy, its effectiveness, real or envisaged, in bringing about the ultimate human end and good. And we see this in jus cogens instead, in the doctrine of jus cogens, as if it was. I was once said that they are that by litigating as a human rights lawyer before international courts without the notion of jus cogens, I was like a Jedi without the Force, because they are supposed to bring the end and good for human life. But they are not, and we are not going to bring them through norms. This is present in the debate of moral absolutes. As for the methodological questions that we learned from the debate of moral absolutes, just to keep myself within the time, moral absolutes are not absolutism. They are more than commands. We see that they are norms that are not supreme, fundamental, or unconditioned. To call them absolute is to say no more than they are exceptionless. Exceptions to them are logically impossible and readily conceivable, but are morally excluded. That's what it means, exceptionless, in moral absolute. Not a sort of absolutism, as we see in the doctrine of jus cogens that wants to trump all other norms in national jurisdiction and international jurisdiction. Exceptionless norms are few, whereas the drive towards jus cogens is always in crescendo and invasive into everything that one can think of a public order, a desirable public order, as perhaps some neo-constitutionalists describe an omnipresence of rights within the legal system. Also, we learn from the moral absolutes debate that never means never. They are valid semper ad semper. If they are absolutes, maxims, non-negotiable, imperative, they are so even in cases of supreme emergency. There's no weighing of these principles. And yet, when we see jus cogens in action, we see constitutional courts weighing genocide with the principle of cultural pluralism from one tribe to another, that disappearing the other tribe is a form of purification of earth, and thus not a genocide. And this happened in a constitutional case in Ecuador, in a case that involved two communities, indigenous communities of uncontacted people in the Amazonia. So I would end here my remarks. So we can truly live our lives with the assurance that no matter who in power is, because no one will be able to argue that securing or respecting the common good includes the injustice of getting ready to ignore the essential protection of basic human goods for any purpose. This is not what the doctrine of moral absolutes does. On the contrary, it says what is good, hold goods, and we cannot, not in spite of who is in power, go against it. Nowadays, instead, it would be possible that the jus cogens prohibition of torture would be superseded by national constitutions in matter of investment, commerce, because some courts, like in the case of Colombia, have interpreted that a river cannot be tortured. So, well, I will stop there and, with the remarks. I will be open to more questions on how these norms, the idea of moral absolutes, as Professor Finis puts it in the beginning of his work, these are moral norms whose truth is now contested, but they are decisively important for conscience, conduct, and civilization. And this is why I think they offer a step closer to the set of principles of natural law and the method of practical reasonableness in international law. Thank you.